All right. Um, who will likely prevail? Since that doesn't tell us much, I go up. The investor sued, circle investor, sued. So we know he's the plaintiff. Label him. The cousins, and circle the cousin. And then specific performance. So we know we're under the umbrella of specific performance. And so I'm thinking there's a buyer and seller, and someone doesn't want to perform, and somebody's asking the court to force the other to sell or to act. A, the cousin, circle cousin, because the contract to convey was not signed by the legal owner of the farm as of the date of the contract and was therefore void. So contract not signed by legal owner and therefore void, that to me doesn't, I don't think that's true. Like, just because the signature is not there doesn't mean that it's void. The cousin, because she received title by device rather than by conveyance. Well, device means by will, conveyance means that someone, it was a contract for sale. But I don't think that either one of them have any superiority to the other. So I would maybe even strike that, even A, for now. And then the investor, circle the investor, because the contract to convey merged into the executor's deed to the cousin. Merge is talking about the contract for sale merging into the deed after the sale. And I'm not sure if that's part of specific performance, but I'll see depending on the facts. D, the investor, circle investor, because the contract to convey remain enforceable by her within a reasonable period of time after the proposed closing date. So I would underline enforceable, reasonable time, a reasonable period. And that kind of sounds good, but I'll see. So I go to the top. 6 months ago, a man told his cousin that he would give her his farm. So circle man told his cousin that he would give her his farm as a gift. So farm as a gift. So she didn't pay value. On her next birthday, the cousin then entered into a valid written contract to sell the farm to an investor, with the closing to take place 1 week after, and then circle investor, the cousin's birthday. The man failed, failed to convey 1 week. The man failed to convey the farm to the cousin on her birthday 1 week after the cousin's birthday. On the intended closing date, the investor first learned of the cousin's inability to convey the farm because the man had breached his promise. The investor considered suing the cousin, but realized that she could not compel the cousin to convey the farm because it was still owned by the man. 2 weeks after the cousin's birthday, the man died. So man died. Under the will, the man devised the farm to the cousin. So man, farm to the cousin under the will. Circle that. Farm to cousin. Within a week, the executor of the man's estate gave the cousin, an executor's deed to the farm in compliance with state law. So I would circle executor because he's a new party. The investor promptly learned of this transfer and demanded that the cousin convey the farm to her. The cousin refused. The investor sues the cousin for specific performance. Who will likely prevail? A, the cousin, because the contract to convey was not signed by the legal owner of the farm as of the date that the contract and was therefore void. That's not true. Cancel that. The cousin, because she received title by device rather than by conveyance. Yeah, no, that's out. The investor, because the contract to convey merged into the executor's deed to the cousin. That's not true. It doesn't merge into the executor's deed. It's between contract for sale and a deed. And then D, the investor, because the contract to convey remain enforceable by her within a reasonable period of time after the proposed closing. I like that because she had a contract with the investor, even though she didn't have title to convey, the contract was still enforceable. So I picked D.
Okay. Now the answer is, hang on. Now the answer is, ta-da!
D, correct. The cousin and the investor had a valid contract for the sale of the farm. The contract did not specify that time was of the essence, and thus the investor should be able to enforce the contract within a reasonable time after the proposed closing date. The cousin acquired the land 2 weeks after the intended closing date, which was within a reasonable period after. I like that. From all the other ones.
Okay, first, if I do it, okay, this is the way I would do it. When you read and you try to strike, try to be patient. Don't rush through the sentence.
Okay.
So we know, and you know, that we are now at the Pacific Performance. Okay. We now, your guy know now we are at Pacific Performance. That's the topic. Okay. And you understand what is Pacific Performance about. A, who will prevail? A, the cousin, because the contract convey was not signed by legal owner and the form and Okay, not signed. Okay, so if it's not signed, then there's no contract, right?
With no enforceable, right? By the party it didn't sign.
Right, but who cares whether it's signed or not signed? If the document is not signed, if the document is signed and you don't want to sell me, I still can sue you Pacific Performance. If the contract is bad and it's not signed, I still sue you for Pacific Performance. You see it? So it is whether or not sign or doesn't sign has nothing to do with Pacific Performance. See that?
Yeah.
So A is out. Because if you look at the word Pacific Performance is you suing something that don't have to be in the contract. That's a good thing about Pacific Performance. Okay?
And I always think not signed is more SOF, statute of frauds.
Right. Very good too. Yeah. So and you and that's also put that in your mind when you see signed or not signed. B, the cousin, because she received title by device rather than conveyance. So are you telling me this make a difference whether how you received a property? So you cannot sell to me, or because someone gave it to you, your father died and give it to you, you're telling me you cannot sell it to you because you didn't purchase? It doesn't make sense. It doesn't make sense how you got it. This is when you buy something, it doesn't make sense how you got it. Oh, before I buy your land, how do you get that? No, you don't care of how you got it. All you care is whether you have a marketable title. So B should be strike already. Struck. Then the investor, because the contract convey merge to the deed, to the executor deed and the cousin. And the word here, B is correct, is merged. What the hell merge or don't merge have to do with specific performance? Specific performance is I want you to do something. I don't care where it is. You see, that's a unique thing about specific performance. So it's also C is out. If you understand the concept of specific performance, the only thing left is D. Now D makes sense. The investor, because the contract conveys the oh, by the way, you don't want to circle on the exam. You don't want to circle D and move on. You only circle D, move on when you want to catch up the time. 17, 34, 51, 68, right? And 85. When at that time, you want to save you some time so you can catch up, then circle D. Otherwise, you leave D. You want to read D and see if D marinate with the facts. And up here, it marinated because it has the word closing date. See? They intended there's a closing date, but there's no date. Right. Whenever there is no date mentioned, then we know that in the past we used a reasonable time. If there is no money in the contract, then we use a reasonable fair price, market price. But otherwise, you got to be a lawyer and focus in the terms of the contract. The term of the contract is the master, and that's how the bar examiner tests you. So D, marinate with the fact. Circle it, move on. I would give B 95% because B wasn't, B leaved C alone.
I did. I should have struck it.
Yeah, you got, you, okay, and then now that's good also, B. The last time we did it, I strike D. And everybody go, Mr. V, D is the answer. I said, well, D is not the answer. I still strike D because D is one of those words that give me that majority of the time wrong. But when I read A, B, and C, they all wrong. They all wrong. So I go back and open up D. And so when I open up D, it does make sense with the facts. It does make sense with the facts. Okay. All right.